Good morning, good afternoon, and good evening. Welcome to Course 3B of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, the Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is monitoring and implementation of treaties to defend people's rights. Our faculty for this course includes Jamil Dakwar, Benyam Mezmour, and Olivier Deschutter. Each of them will speak for about 40 minutes. Then they will comment on each other's presentation, followed by question and answer with the registrants. We have French, Spanish, and English translation. Please put your questions in the Q&A box for our discussion following the presentations. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. Jamil Dakwar is an international human rights lawyer and expert. He is currently the director of the American Civil Liberties Union's Human Rights Program. He serves as the ACLU's main representative to the United Nations and leads the ACLU's advocacy before other regional and international bodies, including the Inter-American Commission on Human Rights. Jamil was one of ACLU's first legal observers to the military commission system at Guantanamo Bay in 2004. In 2020, he was appointed as a member of the New York State Advisory Committee on the U.S. Commission on Civil Rights. Prior to joining the ACLU in 2004, Jamil was a research fellow with Human Rights Watch, and before moving to the United States, he was a senior attorney with Adalat Justice, a leading Palestinian human rights group in Israel. Jamil serves on the board of the International Service for Human Rights. He is adjunct professor at New York University and Hunter College. Jamil will discuss the United Nations treaty body system and the Universal Periodic Review. Benyam Dawit Mezmour is a professor at the Faculty of Law, University of the Western Cape in Cape Town, South Africa, and he serves as Deputy Dean for Research and Postgraduate Studies at the faculty. He is also coordinator of the Children's Rights Project at the Dullah Omar Institute for Constitutional Law, Governance, and Human Rights at UWC. From 2022 to 2023, he served as Eleanor Roosevelt Fellow at the Harvard Law School Human Rights Program. Since 2012, he has served on the United Nations Committee on the Rights of the Child and was its chairperson from 2015 to 2017. At the regional level, Benyam served on the African Committee of Experts on the Rights and Welfare of the Child, a treaty body of the African Union, for a little over a decade, from 2010 to 2021. He served as its chairperson twice, from 2012 to 2014 and 2015 to 2017. In 2018, Pope Francis appointed him to serve on the Pontifical Commission on the Protection of Minors. Benyam will discuss the role of treaty bodies in responding to human rights crises such as the one in Gaza and the African human rights system and its treaty bodies. Olivier Deschutter, UC Louvain and Sciences Po, is the United Nations Special Rapporteur on Extreme Poverty and Human Rights. He was the Special Rapporteur on the right to food between 2008 and 2014, and a member of the Committee on Social, Economic, and Cultural Rights between 2015 and 2020. Olivier will discuss the role of the special procedures of the Human Rights Council. And we will begin with Jamil.
Thank you very much, Marjorie, for this introduction and for organizing and leading this important academic academy or seminars on international human rights and different topics. That's so timely. I want to thank everyone who made this happen. I also want to start by saying it's not an easy time for the international human rights system and also the belief in international accountability for human rights, given the atrocities that is being committed in Gaza. And I know that our colleague Binyam will be addressing that, and I hope that I will be able to share some personal comments on his presentation later on. I was asked to specifically present on the international treaty body system, as well as the Universal Periodic Review, which is part of the Human Rights Council. These are two separate systems that monitor human rights violations in the world. And I'd like to start, though, with a brief introduction to the international human rights system and in particular international law. How do we get to these two different systems? And I will be sharing my screen and share some of the slides with you. Just to start with, important to say that something that is obvious to, I hope, all the audience that we have today, that the human rights really are human rights. Someone has them because they are human beings. They are inherent. And we tend to talk about international human rights as inalienable, universal, interconnected, indivisible, and non-derogable. The last one you can see with a star, non-derogable, is because there are certain situations, particularly in a time of emergency, that with the specific restrictions and conditions and circumstances, that certain obligations of states that could be derogable in a particular time, and which has to be, there are certain conditions that have to be met. We may not be able to get to that in the presentation, but I'm happy to answer those questions. But these are really the core principles of the international human rights that have been developed since 1948 or since the end of World War II. And essentially, what was being agreed as a consensus internationally, that every nation, every country is responsible for protecting and promoting human rights. And that's been reaffirmed, particularly during the World Conference on Human Rights that was held in Vienna in 1993. That notion of universality and the fact that the governments and states are the main responsible for the main obligations for human rights and in their implementation has been then translated more so in different ways that we will be discussing later, particularly how those international obligations should be implemented and protected, and the rights should be protected. So what is international human rights law? Just to cover it very quickly, it's a former expression of inherent human rights, right? Those very inherent human rights that our people have because they're human beings. And there are two primary sources for international law. The first one is treaties that we will be discussing, and we will go over some of the main treaties that were adopted by the United Nations or under the auspices of the United Nations since the 1960s. And the second source of international law is customary international law. The one that we see, the customary international law, is much less used, both in terms of enforceability at the national level, but it is still a very important source of international law. When we talk about international human rights treaties, we have to remember there's a different ways that they are referred to or different terminology used, but essentially they are agreements between countries that they will be bound by certain set of rules and obligations. So they are multilateral agreements. And sometimes they are referred to as covenants or conventions or charters. Sometimes there are addition to that, some additional agreements made as part of protocols, etc. These are all would be used or have been used by the international human rights instruments that have been adopted over the years. And it's also important to distinguish between two processes that in terms of incorporation of international human rights, particularly with regards to treaties. There's the signatures, signing of a treaty, usually is done after a treaty is being negotiated between different governments and is being signed usually by the state, usually by the head of the state. In the United States, for example, is the president has the powers to negotiate and to sign a treaty. But then the more important part is the ratification of the treaty. That is when the treaty is being accepted and the obligations that are in the treaty are accepted as a matter of law and become legally binding, both internationally and then by incorporation into the domestic system, the treaty would be adopted by the state, by the government, by the country. And the term that is often used when it comes to international human rights law as well as other contexts is a state. When a country or a state is signs and ratifies a treaty, they become state party to the treaty. Domestic incorporation varies from different country to a country. Some countries have in their own constitution incorporation of international human rights treaties or international law in general, but some countries have specific mechanisms to or constitutional way of incorporating international human rights treaties. For example, again, in the United States, we have after the president signs a treaty, he or she have to send the treaty to the Senate, and the Senate, which is one of the two parts of the U.S. Congress, the Senate has the authority to provide the advice and consent, and by a vote of 2/3 of the Senate to ratify a treaty. So what are the key international human rights treaties that have been adopted since 1948, following the adoption of the UN Declaration of Human Rights, which we will touch on very briefly? So the first one is International Convention on the Elimination of All Forms of Racial Discrimination, the ICERD. And it was ratified, just for the United States audience, was ratified by the United States in 1994. The International Covenant on Civil and Political Rights, it was ratified by the United States in 1992. It was adopted in 1966. The Convention Against Torture and Other Cruel, Inhumane, or Degrading Treatment or Punishment. This is the third main human rights treaty that the United States ratified, and it was ratified in 1994. The International Covenant on Economic, Social, and Cultural Rights. The Convention on the Elimination of All Forms of Discrimination Against Women. The Convention on the Rights of the Child. And then the Convention on the Rights of Persons with Disabilities. The International Convention on the Protection of All Migrant Workers and Members of their Families. And finally, the International Convention for the Protection of All Persons from Enforced Disappearance. Sorry about the typo there. These are the core or the main international human rights treaties that were adopted. And you can see that sometimes the term is covenant or convention. There were also additional treaty protocols that were adopted following these treaties. These are, some of them are optional protocols, or some of them are meaning open. The country that has ratified a treaty has the option of also ratifying the optional protocol. Usually the optional protocol adds additional obligations as far as, for example, in the context of the International Covenant on Civil and Political Rights, there's an optional protocol on the abolition of the death penalty. So because the ICCPR as a treaty does not categorically ban the use of the death penalty, but only limit the use of the death penalty to heinous crimes with due process protections, as well as other protections. But there's an additional protocol that was added for those countries that that want to be part of the abolition of the death penalty. There are also protocols related to the use of the complaint mechanisms, for example, for certain treaties that were not incorporated into the original treaties. There are other aspects of the treaties that were incorporated in the optional protocols. We will not have the time to go over all the optional protocols, but I wanted to give you just a brief overview that these optional protocols are also important. There are also sometimes additional ways that, for example, in the context of the prevention of torture, there is mechanisms in addition to the Committee Against Torture that is in charge of preventing torture, and countries that have adopted the additional protocol to the Convention Against Torture is obligated to create preventive mechanism to prevent torture and other cruel, inhuman, and degrading treatment. And there is a subcommittee to the that is in charge of the compliance with the requirements. As you can see from this
Como
chart,
pueden
this
ver
slide.
de esta tabla, en esta diapositiva,
I'm hearing translation. As you can see from this slide, this is the number of state parties that joined the different treaties that we just had in the previous slide. The most ratified treaty is the Convention on the Rights of the Child with 196 state parties. These include also parties that are not full members of the United Nations. For example, the state of Palestine that doesn't have a full membership of the United Nations have been able to join the CRC. Likewise, the Holy See, or the Vatican, is a party to the CRC. That's why the number here, 196, is over the number of the United Nations members. You can see that the lowest ratification is for the International Convention on Migrant Workers and the Rights of Migrant Workers and their Families at 59. And now the committee, the Convention on the Rights of Persons with Disabilities is reaching nearly unanimous or consensus or ratification from almost all members of the United Nations. There are still few members, including the United States, that has not ratified the Disability Rights Convention. I would like to now quickly go into the international system of human rights, and just to say that when we talk about international human rights system, they are, or the global human rights system, it really comes from the United Nations itself, that has taken on itself to not only adopt the UN Declaration on Human Rights, but also the human rights treaties, and created different mechanisms. Some of them are treaty-based mechanisms, treaties that were created, monitoring bodies, or committee of experts that were created by the treaties that were ratified by the countries. But there were also other mechanisms that we will be discussing that were created by the United Nations, particularly the General Assembly, over the years, including the most important one and the highest United Nations human rights body, the Human Rights Council. But the universal system has the United Nations, and then you have the regional systems that I will not be discussing, but I think my colleague Binyam will be speaking about the African system, where there are regional systems such as the Inter-American System for Human Rights, the European System for Human Rights, and the African Commission on Human Rights and the African Court of Human Rights. As far as the universal system of protection of human rights, you have United Nations charter-based bodies that were created, meaning created by the UN Charter itself. The UN Charter itself, and we will briefly touch on it, was adopted in 1945. That is the charter that created the United Nations. And then we have the international treaty body systems that were, again, as I said, these are treaty bodies that were created by the treaties that were ratified, adopted by members of the United Nations over the years. As far as the UN Charter, which really created the UN system, It was signed in 1945 or adopted in 1945. It was part of the post-World War II era of instituting, creating, promoting security, fundamental human rights, and peace. And obviously, we could add to that development as well. It provides operational structure and purposes for the United Nations. It highlights commitments to human rights and fundamental freedoms in the preamble and the purposes of the United Nations. The human rights are mentioned about 7 times in the very long document, only 7 times, because at the time it was not as prioritized as it is today. Some may argue that it's never really been as prioritized as other component of the United Nations, particularly security and peace and other functions of the United Nations. But for example, in Article 1, Section 3 of the United Nations UN Charter, it's clear that one of the purposes of the UN was created to achieve international cooperation in solving international problems of an economic, social, and cultural humanitarian character, and promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. This is, I think this is a little bit an older chart of the United Nations. You can see that the different functions from the General Assembly, Security Council, the Economic Social Council, the Secretariat, including the International Court of Justice as a body that advises the United Nations and is the highest judicial body. And again, our colleague Biniam will be addressing that as part of the context of the ICJ case related to genocide in Gaza. But the UN Charter created the General Assembly of 193 members right now. Originally, it's 51. It created the UN Human Rights Council in 2006. That council, this Human Rights Council, replaced the UN Commission on Human Rights that was originally adopted or created by the UN Charter or by the United Nations, and was led initially by the former First Lady of the United Nations of the United States, Miss Eleanor Roosevelt. Of course, we have, in addition to the General Assembly, you have the UN Security Council, but essentially the creation, the start of the United Nations human rights system started with the adoption of the United Nations Declaration of Human Rights, which was adopted by the General Assembly on December 10, 1948. That is why International Human Rights Day is celebrated on December 10th every year. And the declaration, we're gonna go through it very quickly, has 30 articles expressing the fundamental rights which all human beings are entitled to, including economic, social, and culture, civil and political rights. I would want to just skip those comments, and we can come back to it as far as the way that the United States, I will be addressing some of the history of United States engagement, but we know that the United States has been part of creating the UN itself, as well as the UN human rights system, but however, it has taken a position of distancing itself from accepting legal obligations, particularly, and creating enforcement mechanisms within the United States, and we will talk more about that, and the way that U.S. policy and practice has failed to live up really to what was expressed in the Universal Declaration of Human Rights, and the creation of this separation between U.S. foreign policy and the use of human rights in the U.S. foreign policy, rather than accepting human rights in the domestic as part of domestic policy. And we continue to have challenges and serious problems with that sort of distinction or intentional rejection or lack of incorporation of human rights domestically. But the Universal Declaration of Human Rights is worth reading it for those who have not read it. Really, for 1948 is a pretty radical document in terms of what it really said about recognizing the inherent dignity and of the equal and inalienable rights of all members of human family. That is a foundation for freedom, justice, and peace in the world, right? These are really the sentiments that and the values that were shared by the founding members of the United Nations, and also the other members of the United Nations that joined the UN. Again, I'm just going to go skip some of the articles. We can share the slide, but you should read the different articles that relate to different parts of the declaration. But I want to jump to the most recent human rights body that was created by the General Assembly. That is the UN Human Rights Council. It was created, as I said earlier, in 2006. It replaced the UN Commission on Human Rights that was in charge of monitoring implementation and monitoring human rights, reporting to the General Assembly on human rights violations around the world. The Human Rights Council was created with an intention to ensure that human rights are truly universal, that the accountability for human rights that are not being politicized in the way that would make human rights less effective in monitoring human rights, less effective, and subjecting essentially all members of the United Nations, regardless of whether they joined or ratified or have not ratified human rights treaties, to a single human rights process where their human rights record would be assessed, would be scrutinized, and there would be recommendations for improvement. So the Human Rights Council itself was a fresh breath, in a sense that it had brought a new era of ensuring that no matter how big the country is, no matter what its history is, it has to be held accountable to the Universal Declaration of Human Rights, to all the other international human rights norms and values that have been included by the United Nations Charter, the United Nations Declaration on Human Rights, and other international commitments on human rights. So it has 47 member countries. Those countries are elected by the human rights, by the General Assembly on geographical basis. Countries can put their candidacy forward. Again, the way that these candidacy should be supposedly reviewed based on their commitment to human rights. There has to be adhering to, of course, the resolution that created the Human Rights Council, and they would make pledges and promises and commitments before they are elected to the Human Rights Council. The General Assembly elects those members based on geographical regions of the United Nations. Unfortunately, in recent years, there has become less and less competitive process where countries have to compete and to show their respect and commitment to human rights is being, and therefore sometimes you have regions where there's no competition because there are the same number of countries running for the number of open seats for the council. However, there's a pushback from civil society organizations and some countries that are calling for more accountability and transparency in this process, particularly holding those countries that have serious violations of human rights from not becoming members of the Human Rights Council due to their human rights record. The Council commissions reports, adopts resolutions, and on global human rights issues, and you will hear from Olivier about one of the main functions of the Human Rights Council is to hear reports from special rapporteurs or special procedures that are appointed by the Human Rights Council. The Human Rights Council meets 3 times a year, usually there's a session in March, April, and then again in June, July, and in September, October. They can hold also special sessions or hold urgent debate on emerging human rights crises in the world. And there are, these usually are happening when there are some serious and egregious violation of human rights happening rapidly that cannot wait for the Council to convene during a regular session. As I mentioned, the Council has the authority to appoint independent human rights experts or special rapporteurs, as well as fact-finding mechanisms or commission of inquiry, which is the highest level of accountability that the Council can do as far as addressing serious human rights violation situations. And more importantly, the Council has this process of that's called the Universal Periodic Review, which reviews the human rights record of all 193 countries that are members of the United Nations, including, I should say, also the observer states as well, not just the ones that are, and that process has been going on since the late 2000s, and we have so far 3 cycles that have been concluded. Each cycle is about 5 years. Each country has to be reviewed by the Council every 5 years. The process for the Universal Periodic Review is based on a report that is provided and submitted to the Human Rights Council by each country. The report is usually about 20 to 25 pages long, or not very long, that has to address different aspects of human rights, again, regardless whether the country has ratified a treaty or not. They have to also provide answers to why they have not ratified treaties, and offer other answers related to enforcement of human rights at the national level, in addition to the protections of human rights by adopting laws and ensuring that the rights are protected, including the right to effective remedy. In addition to the national report that's usually submitted by each country, the United Nations Office for Human Rights, or the Office of the High Commissioner for Human Rights, prepares something called a stakeholders report that consists of other sources of for human rights record of the country, including from civil society civil society reports that are submitted to the Human Rights Council in order to assess and to provide alternative assessment of the human rights record of the country. And the United Nations Office of the Human Rights, or the High Commissioner for Human Rights, also provides a summary of the record that was created over the years by the special rapporteurs, by the United Nations treaty bodies, based on examination of their record. And we will talk a little bit more about particularly the treaty body reviews. And once those documents are submitted, there is a session that's held in Geneva before the Human Rights Council, where countries, members and non-members of the Human Rights Council, not just the 47 members, also non-members and observers, can participate in the review by raising questions to the government that is being reviewed, by raising recommendations and critique of their human rights record. Civil society organizations also usually have limited opportunity to intervene by making brief comments and interventions regarding particular countries that are being reviewed. The government usually send delegations to Geneva. They respond to some of those questions, to some of those recommendations, and at the end, there's a report that is being submitted by a working group, consists of a troika, 3 states, members of the Human Rights Council that are appointed for each review. And this working group report for a country examination or review is being adopted by the Human Rights Council at the end of each UPR review. The country has to come back and respond to the recommendations, which recommendations they will be accept in full, which will be accepted in part, and which will be rejected. You can see there's very detailed website by the Office of the High Commissioner. If you put UPR or Universal Periodic Review, and then each country has its own page. Each country has its own UPR page. So you can put United States UPR, and you have the UN UPR page for the United States that will have the record of all the reviews that happened for the country. For example, the United States last time was reviewed in 2020. The next review will be in 2025. There's also a practice, it's not mandatory, that some countries do a mid periodic evaluation. So after 2.5 years, countries submit a report on progress made to implement the recommendations that were made by the UPR. It's important to note that this is a peer review or peer process, meaning that this is not a experts-based review. This is a review that has happened by members of the Human Rights Council and other observer countries or states to other countries. So it's an intergovernmental review. Countries review each other's the human rights record, and oftentimes this is subject to their foreign policy related to those countries. There's often the use or misuse of this process in order to either criticize more harshly countries that are not in good diplomatic relations with other countries, etc. But the importance of this process is that it doesn't single out one particular country. All countries have to follow this process. All countries have to be subject to this review. The information that is gathered for the assessment is also consistent and pretty comprehensive as far as receiving information from civil society organization. They don't have to be members, have a special status with the United Nations. Any organization or member or people come together, movements, grassroots organizations can participate by submitting these submissions to the United Nations Office of the High Commissioner, and then these will be summarized and used and provided. So even if it's not perfect in the sense that it is usually very brief, the session is only a 3-hour session. You can imagine that it's hard to discuss and review fully and comprehensively every 5 years, only in a 3-hour session or less. Countries, especially the big countries, big powers that have serious human rights violations record. And the other thing is that the enforcement is not really optimal or is not effective, because there's no enforcement mechanism other than publishing the working group report and depending on the political will of the governments and the countries to do the follow-up with participation with civil society organization. There's no specific follow-up that happens only after 5 years. The country is back before the council again for the review. So there's obviously much more to be desired in terms of improving this process, as far as allowing more direct follow-up with the countries and demanding more accountability for follow-up and implementation as part of that review, rather than just leaving it as a report. But again, this is part of the negotiations for creating the system. And as you can imagine, governments don't like to be examined for their human rights violations and record, and therefore they're leaving it to diplomacy, media scrutiny, civil society pressure, and advocacy to implement these UPR recommendations. With that, I want to quickly move to the other side of international human rights accountability mechanisms, that are the treaty-based bodies that are created by human rights treaties that are adopted. And you can see here, this is the chart with the courtesy of the Center for Civil and Political Rights in Geneva, the human rights treaties, and then you can see that the different treaties and the optional protocols again, the different ones. And then on the bottom line, the bottom row, you see those are the treaty bodies that were created. So for example, for the International Convention on the Elimination of All Forms of Racial Discrimination, you can see on the left side of the middle row, this treaty that was adopted, one of the first treaties to be adopted by the United Nations in 1965, created the Committee on the Elimination of Racial Discrimination to monitor compliance with the treaty. So what are the functions of the treaty bodies? First, they consider state reports. So they receive, again, periodic reports submitted. First, there's an initial report that's submitted after the ratification of a treaty, and then now unfortunately the period is much longer. It used to be 3 to 5 years. Now it's every 8 years. The country is supposed to submit periodic reports to the treaty body. And so these reports are considered by the treaty body. The second thing is considering, again, sorry for the typo there, considering individual complaints. In some treaties, they allow individual petitioners that have exhausted domestic remedies to appeal or to petition the treaty-based bodies, these human rights these committees that were created under the treaties, in order to adjudicate essentially violations of human rights under the treaties, and particularly looking at the state's compliance or incompliance with their obligations based on the facts of these individual complainant people who have their rights were violated at the national level, and they have not succeeded to be able to receive a remedy, or their rights were continue to be violated, and so they are able to bring their case to the treaty bodies. Some countries accepted this individual communication procedure. Some countries have not accepted those either. Through the ratification, they said they made it clear that they are not accepting this individual complaint procedure. For example, the United States have not accepted any of the individual complaints procedure for any of the treaties that it has ratified. Some treaties, they have optional protocol that created that individual complaint mechanism. The third function of the treaty bodies is adopting general comments. General comments are essentially the vehicle, the mechanism by which the treaty bodies interpret. They try to provide guidance to state parties, to the governments, the countries that ratify those treaties, how to implement, how to ensure that the treaties is implemented at the national level. And they usually also interpret the different provisions and articles. So usually they take an article and they let's say an article related to the right to life, for example, under the ICCPR, and they come up with their own interpretation, and this becomes part of what we call authoritative interpretation of the treaty by these experts bodies. And I think for the exception for the CERD, all of them call them general comments. For the CERD, it is called general recommendations when they adopt these interpretations of their provisions and articles and state obligations. And the last one, some of the treaty bodies also have the power and to conduct special inquiries, special investigations. For example, the Committee Against Torture has the ability to conduct special investigation for widespread violations of the treaty when their torture is so systematic. For example, the Committee Against Torture did that. I believe it tried to do that with regard to Egypt more than 20 years ago. Some mechanisms also have interstate mechanisms for adjudicating compliance or lack of compliance with the treaty. For example, the Convention on the Elimination of All Forms of Racial Discrimination has that interstate process, and it's been used only 4 or 5 times so far. The last one that was used by the State of Palestine against Israel for violations of the treaty in the context of creating a system of apartheid, as was brought by the state of Palestine. The UN treaty bodies consist of independent experts. They are elected by state parties, meaning they are nominated by the states, that is state party, but they are elected by the General Assembly, or the state parties assembly. All the different countries that ratify, not the General Assembly of the United Nations, but rather the assembly of the state parties that ratify the treaties, have the power to elect members. They're elected for 4-year terms. They meet mostly now in Geneva. They used to be meeting also in New York, and they are supported by the Office of the High Commissioner for Human Rights Secretariat. And they are the ones who put forward the working methods and rules, and the ones that conduct the periodic review for when the governments are up for review. These independent experts usually are elected based on their expertise and their independence. They're not supposed to be associated, in meaning they're not representing their own country. In fact, when their country is being reviewed, they're supposed to recuse themselves from participating in the review. The treaty body review is one that is much more open to civil society organizations, because the review itself is largely based on shadow reports submitted by peoples and their organizations as alternative information, alternative analysis and critique of government's reports, because governments oftentimes want to present much more optimistic or rosy reality or situation, which is usually not accepted or not really reflecting reality on the ground. So civil society organizations, again, they don't have to be affiliated with the United Nations. They don't have to have a special consultative status. They only have to follow the rules that are created by each treaty body in order to submit information before the review itself. Usually the government submits a report. After the submission of the report, there is a chance for civil society to submit their own information, and based on that information, the committee also develops what it's called list of questions or list of issues that are the main issues that are being discussed during the what they call the interactive the dialogue between the committee of experts and the governments. Some governments have adopted a new procedure for review. It's called the procedure that allows the government to provide a report based on a list of questions. So the list of questions is initiated by the committee based on civil society input, and then sent to the government for their periodic report. And once that report is received, then the review is scheduled. There are usually 2 sessions or meetings of the expert bodies, 3 hours each, during which the government delegation representatives will be subject to questions from the committee of experts. Civil society organizations are allowed to be present and observe. They usually have a chance to brief the committee members in informal and formal briefings, meaning formal briefings on the record where there's a translation by UN interpreters, and they are allowed to engage with committee members freely, meaning in an informal way, to continue to provide information and input on the government responses. At the end of the review, normally the session takes place between 3 to 4, sometimes even 5 weeks in Geneva. The committee adopts what they call concluding observations. I'm going to skip through to show you this. This is the kind of way, like an example of the concluding observation, just as an old one from 2006, again, after the United States was reviewed by the UN Human Rights Committee. I mentioned earlier the different treaty bodies that were created. For example, for the ICCPR, the Human Rights Committee was created to monitor compliance. For the ICERD, the Committee for the Elimination of on the elimination of racial discrimination. Then you have the Committee Against Torture and so on, other committees that were created. I would like to, in the last 5 minutes or so, if I may, just to go over some of the history of U.S. engagement, if that's okay. And then I will conclude in about 5 or 10 minutes. Is that okay?
Yes, that's fine, Jamil. Thank you.
Thank you. First, I just want to mention one of the things that usually happens when countries ratify treaties. They include reservations, understanding, and declarations to the ratification of the treaty. And just as an example, I want to give you an example of what for example, the declarations, the RUDs, as we call them, that were adopted by the United States when the United States ratified the first main international human rights treaty in 1992. That is the International Covenant on Civil and Political Rights. It had entered reservations related to protection of free speech under the U.S. Constitution, particularly because it was made as part of that reservation. The United States said the United States would not accept restrictions on free speech as part of the covenant, and would only be able to comply with Article 19 of the ICCPR on free speech, consistent with the U.S. Constitution that provides greater protection for free speech. Unfortunately, in the last few days and weeks, we know that that's not always true, and in fact that there's much the U.S. has to do in order to fully protect free speech in different contexts. They also entered a reservation on the use of the capital punishment, particularly when the United States ratified in 1992. The United States was still allowing the execution of juveniles, and that reservation is still there, even though the United States Supreme Court had banned or outlawed the use of the death penalty against minors. It's still, this reservation has not changed. The United States still uses the death penalty, but in limited crimes, and only for heinous crimes, and only for limited jurisdictions. But yet, this reservation stands. Then there's also another reservation related to the application of Article 7 that requires prohibition of torture, cruel, inhumane, degrading treatment, or punishment. And the United States limited the prohibition against cruel, inhumane, degrading treatment, or punishment to the constitutional prohibition under the 5th, 8th, and 14th Amendment. Under the 8th Amendment, there's a prohibition of cruel and unusual punishment, and that's actually was one of the ways that the United States, for example, used those reservations in order to justify the use of torture after 9/11, including the reservation that was entered to the Convention Against Torture. So just to give you an example on how those reservations oftentimes limit the applicability and enforcement of very core human rights. And lastly, the issue of treatment of juveniles as adults, as many of you know, in the United States, children can be tried as adults and could be subject to trials as adults as young as 12 or 13 years old. So the United States entered this reservation in order to allow itself to be part of the ICCPR, and yet, although there has been some changes to some laws in certain states with regard to the use or to treatment of juveniles as adults in the criminal legal system, but it's still, this reservation stands. It also added a understanding that given the federalism system that is in the United States, that the treaty shall be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over matters covered by the treaty, and otherwise by the state and local government. This understanding is somewhat, unfortunately, is not well understood, oftentimes misunderstood as not allowing state and local governments to be under the international human rights law, governments have to abide by the treaty at all levels. It doesn't matter if they have a federal system, if they have local, or provide some powers to local and state or government, provinces. The national government is responsible to ensure that the application or the enforcement of the treaty at all levels. In fact, it is part of certain articles in different human rights treaties. And finally, they also added declaration that the U.S. Would not see the articles, the main articles of the ICCPR as self-executing, meaning that they are enforceable without having to have Congress and legislature to adopt implementing legislation. And that's one of the impediments to full enforcement of human rights treaties, at least in the United States. It also intended to limit, as I said, the ability of litigants to sue in court for direct enforcement of treaties. This is, for example, one of the arguments that was made or in the case that was brought by Center for Constitutional Rights against the Biden administration for violations of the Genocide Convention, that the Congress has not passed, as a matter of a reality, has not passed enabling legislation to the ICCPR. It has passed limited legislation in other contexts, particularly in the context of the Convention Against Torture. Finally, I just want to say a word about the way that the United States has exempted itself from. There's been a long history of Black-led organizations, including the NAACP and the Civil Rights Congress, appealing to the United Nations, appealing to international bodies for violations of human rights in the United States. And in fact, many of the organizations that work in this space in the United States are guided and are inspired by this work that was led by the NAACP, the U.S., the Civil Rights Congress, based in Chicago. For example, the Appeal to the World petition that was in 1947, it really was one of the first to be adopted by addressed to the United Nations. We don't have the time. Maybe in the Q&A we can talk about that. But ultimately, it has led oftentimes to external pressure and important changes, including by the executive branch, by political branches of the government, including consideration by the legal bodies and judicial bodies. And I think there are more research and documentation that shows the relationship between the way that international advocacy that has been led by different organizations, including, as I said, the NAACP, but also Malcolm X's campaign to urge African states to raise the questions of persecution of Black Americans in the U.S. at the UN, had really made a difference in terms of the way that the reactions to the State Department and the Justice Department that took interest in what has been said and really influenced and had an impact on the U.S. government, some of the positioning, because of the Cold War era political politics of the time, meaning the United States was trying to promote itself as a beacon of freedom, of democracy, and human rights vis-a-vis the Soviet Union. And yet there has been a continuation of segregation, racial segregation, serious violation of human rights, from lynching to of Jim Crow laws and systems of oppression in the United States. And that was partly why the United States has decided to stay outside some of the mechanisms of enforcing human rights at the national level, because it feared that this could be used by organizations, including Black-led organizations or indigenous rights organizations, to address issues of genocide and issues of gross violation of human rights, particularly in the South. So with that, we have to keep in mind that this is the legacy of the United States participation in the system, but there is also in recent ways of engagement that allowed more scrutiny and accountability for human rights that we're happy to discuss more in the Q&A and maybe in a separate occasion, in the way that advocates and organizers and lawyers and academics and other civil society organizations have brought the international human rights mechanisms and values and norms and obligations to their organizing, using the treaty body system, using other mechanisms that you will be hearing about today, in order to hold the United States accountable, to expose and document systemic racism and other violations of human rights. I want to stop here and thank you very much for your attention.
Thank you so much, Jamil, for your excellent explainer of the structure of international human rights mechanisms, the reporting system of treaty bodies, and the implementation of treaties. Next, we will hear from Benyam. Benyam?
Thank you very much, Marjorie, for that introduction. Thank you very much, Jamil, for the input that you've already provided. It actually gives me a very great platform to build on quite a number of the points that you've made. And then obviously I look forward to the opportunity for a conversation later on. But let me also say thank you very much. I usually do not turn down an opportunity to talk about children's rights. I don't turn down an opportunity to talk about the Convention on the Rights of the Child, the African Charter on the Rights and Welfare of the Child, and of course, quite a lot of the human rights issues that we face today in the world. They have significant implications for the lived reality of children on the ground. Now, I come from the African continent. I'm Ethiopian. I often get the question, why is children's rights important for the African continent? There are a number of reasons why that is the case. It's still a very young continent. We're talking about countries with the highest level of life expectancies, or low number of children per family, are mostly in Malta or Luxembourg or Italy or Japan and so forth. If you want to talk about countries with very young populations per household, you're talking about Malawi, Mali, Central African Republic, Zambia, Uganda, Niger, and so forth. The top 10 are actually within the African continent. Now, I will come to the African Charter on the Rights and Welfare of the Child and the treaty body, the African Committee of Experts on the Rights and Welfare of the Child, at a later stage. I'm going to start with a global one. Let me share my screen. Jamil, can you stop sharing so that I can start sharing? Appreciate it. All right, there we go. So what I plan to do is I plan to say quite a number of things about children's rights, the Convention on the Rights of the Child, with a focus on the treaty body itself that monitors its implementation, which is the UN Committee on the Rights of the Child. As was introduced earlier, I currently serve on that treaty body. I'll say a few things about some of the challenges that we have seen and continue to see in different parts of the world, not just in one specific part of the world, but in all four corners of the world. And then I'll come to the African level. And then, of course, I'll say a few things about children in armed conflict, which is a very important and critical topic today than it was yesterday, for lack of a better wording. So,
Benyam, can you slow down just a little bit for the interpreters, please? Thank you.
Sure. So let me put first things first, a disclaimer. None of what I say today is on behalf of any of the organizations that I'm associated with, particularly the UN Committee on the Rights of the Child. This disclaimer is also important because there will continue to be state parties that will come for a review before the committee. And I don't want any of my remarks to come across as though I'm judging those forthcoming reviews. That's not the intention here. So not on behalf of the committee. This is just in my own personal capacity. The objective of the presentation, as I said, is to build on the very excellent input that was provided to all of us by Jamil. And then, of course, I will narrow it down to one treaty body, or maybe a couple of treaty bodies. So the UN Committee on the Rights of the Child, and of course, at the regional level, the African Committee of Experts on the Rights and Welfare of the Child. Now, let me also say a couple of things about the perception that existed in the early days of the Convention on the Rights of the Child. If you remember from Jamil's presentation, we're very proud about the fact that the Convention on the Rights of the Child has 196 state parties. When I was chair of the committee between 2015, 2017, I used to joke and say, I'm not sure if my name is Arthur or Martha, because the number of states that you actually deal with is absolutely, absolutely huge. I came from a regional system. Within the African Union, there are 55 member states. And then coming to the United Nations level, dealing with a treaty ratified by 196 countries brings its own opportunities, but also significant challenges and limitations, make no mistake about it. But the main starting point is that notion that used to exist to say that, you know, the Convention on the Rights of the Child has this European child in mind, that is actually very biased, that is not going to be relevant for other parts of the world and so forth. Over the years, it has significantly faded into the background. In fact, more and more, if you look at the current literature that exists, it shows that the convention is incomplete, yes, but it doesn't necessarily subscribe to a specific child in a specific region. That's not what it intends to do. That's not what it does. And of course, the interpretation that has come from the UN Committee on the Rights of the Child has also reconfirmed that approach. Now, why do we say just incomplete? I mean, whether we talk about the Convention on the Rights of the Child, whether we talk about the International Covenant on Civil and Political Rights, or the International Covenant on Economic, Social, and Cultural Rights, or even the most recent ones, the Convention on the Rights of Persons with Disabilities. We can quibble with the wording. We can say we should use should here. We should provide for a higher standard here. Maybe there is an argument that the Convention on the Rights of the Child would have been served better if there were references to, for instance, corporal punishment or to the internet and so forth, so forth. But it's also important to view these instruments with a lens that also does justice to the time these instruments were adopted. In 1989, when the Convention on the Rights of the Child was adopted, the internet was just starting. It was not a huge issue. In 1989, 1990, it came into force. HIV/AIDS was still in its early stages. It had not yet started to create havoc in children's lives, particularly in Africa and Asia. So it's incomplete, yes, but that incompleteness is increasingly supplemented through interpretation by the work that is done by the UN Committee on the Rights of the Child, but also by optional protocols. It's not just only the Convention on the Rights of the Child that the Committee on the Rights of the Child monitors. We also monitor the implementation of the two optional protocols, one on children in armed conflict, which I will come to later on in some detail, but also the other one on the optional protocol on the sale of children, child prostitution, and child pornography. Now, the other first thing first that I want to mention is context does actually matter. In the last 11 years, I have had the privilege to sit in a room where multiple countries were being reviewed by the Committee on the Rights of the Child. And it's very obvious to appreciate that context matters. What are these contexts that I'm making reference to? The obvious ones are, for example, your financial resources do matter for the implementation of the Convention on the Rights of the Child. Now, I'm not one of those people who thinks that the lack of money is the root of all evils. Absolutely not. Resources are important. Human resources are critical. Financial resources are critical. But so is political will. Some of the countries that have come before the Committee on the Rights of the Child and surprised us in a pleasant way are not necessarily countries such as Luxembourg or Norway and so forth. Not necessarily. We also have countries that have very limited resources, that are doing exceptionally well on, for instance, on migration issues, on mental health issues, on making sure that child support grants are provided to children that are actually in need, in trying to make sure that law enforcement officials get the necessary training to make sure that the provisions of the Convention on the Rights of the Child are actually upheld. So resources are important. Your historical context that you come from is also important. I am currently connecting from South Africa today, here in Cape Town. The legacy of apartheid and its impact on children's rights and its impact on the implementation of the Convention on the Rights of the Child is still alive and kicking to a certain extent. You can look at the education sector. You can look at the healthcare sector. You know, in South Africa, people say we moved from legal apartheid to economic apartheid, when they often try to emphasize the continuing legacy of apartheid. And that has implications for children's rights. So the history that a country comes from as a context does matter. Whether it's a country that is peaceful or going through conflict does matter. Whether it's a country where it has harmful traditional, cultural, sometimes religious practices embedded in communities, it does matter. Even topography matters. We're having significant conversations about climate change. Small island states, their topography matters. Countries like Namibia, for example, a very huge landmass, significant part of it desert. Where do you place health centers? Where do you place education centers? How do you provide child protection services? Where do you actually locate police offices to make sure that they're as accessible as possible to children? So your topography does also matter. Your foreign dates, because currently globally there is a conversation about the vicious cycle. Quite a number of countries, particularly after COVID, they're defaulting on their debt. So your foreign data, the source of your economy does matter. When I say this, I am reminded about the conversation that we had not too long ago with Uzbekistan, whose economy depends significantly on cotton and cotton production, and how that could potentially affect issues pertaining to child labor, children's access to education, and so forth. I also think about Cote d'Ivoire, whose economy also, to a certain extent, I would say significantly, relies on the cocoa industry, which unfortunately also has significant child labor, which affects education, healthcare, and so forth. So a country's economy does matter. So there are a lot of contexts that have implications for the implementation of the convention, and they need to be understood by stakeholders, particularly the Committee on the Rights of the Child as a treaty body that monitors the convention. So the expression that says a universal but differentiated standard, I would take it to a certain extent to mean that it's important to appreciate context. Now, I've already mentioned about ratification, 196. I say that's a great number to actually work with, but also with it brings a lot of challenge. But there are also reservations, as was already alluded earlier by Jamil. Fortunately, some of the progress that we have seen is that more and more countries have withdrawn reservations that they have entered to the Convention on the Rights of the Child. I'll be honest with you, and I'm not saying this just only for the Convention on the Rights of the Child. I can say the same thing for the Convention on the Elimination of All Forms of Discrimination against Women. Some of the reservations that have been entered into that instrument, they seem to suggest that we want to be a state party to this instrument. We want to be part and parcel of the international community. We want to uphold the standards. But meanwhile, we want to continue to discriminate against women in certain respects, and please allow us to do that. That seems to suggest, some of those reservations seem to suggest that there are similar reservations within the Convention on the Rights of the Child. But again, as I said, more and more are being withdrawn. As a committee, we encourage states to withdraw. And in a number of instances, states have actually responded positively. Now, November 2024 will mark 35 years since the coming into force of the convention. Maybe it's a point that I'll come to in my conclusion later on. Now, let me put this in slideshow. I want to say a few words about this one. It's an open letter to the world's children. 8 reasons why I'm worried and hopeful about the next generation. If you don't know who Henrietta Fore is, She's the former executive director of UNICEF, a formidable force. She's done significant work on children's rights, and she's actually helped to take UNICEF to a new level. Now, these are 8 important points. I'm not going to spend a lot of time on them. The first one says you need clean water, clean air, and a safe climate. UNICEF says the climate crisis is a child rights crisis. If you look at the numbers, out of 2.2 billion children globally, 99% of those children are exposed to at least one form of extreme weather event. It could be flooding, it could be heat wave, it could be drought, desertification, rising seas, whatever the case may be. So it's a critical issue for children's rights. The second one, which is very close to my heart, is the one that says 1 in 4 of you are likely to live and learn in conflict and disaster zones. In different parts of the world, we're experiencing very disastrous conflicts. They're not cost neutral to children. They have devastating effect on children's lives. They dent children's lives left, right, and center. Here I'm talking about Yemen. I'm talking about Sudan, South Sudan. I'm talking about what's happening in the Middle East, in Gaza particularly, Ukraine and Russia conflict. There are also a number of other conflicts which the media often forgets or neglects. But at the end of the day, children find themselves falling between the cracks. The third one, we must make it okay to talk about mental health. One of the things that we've actually learned from the COVID pandemic is about the importance of addressing mental health. And mental health is a very critical issue for children and their rights as well. The fourth one, over 30 million of you have migrated from your place of birth. Migration, again, is a critical issue for children's rights. It's critical for those children that migrate with their parents. It's even more critical for the children who migrate unaccompanied. Thousands of you will officially never exist unless we act. This is actually a very sad fact, because we know about the fact that birth registration is a right from the start, but it's not a given in many countries throughout the world. In a number of jurisdictions where birth registrations do not exist, where nationality issues are very politicized. In just a couple of months ago, I was in Kuala Lumpur in Singapore. We had the World Statelessness Conference. And we're still talking about 9 to 10 million people globally that are at least identified, that are stateless. It's an indictment on the international community. 60% of those are actually children, by definition, persons below the age of 18. 6, you need 21st century skills for a 21st century economy. UNESCO, before COVID, UNESCO used to say, we have a learning gap. After COVID, UNESCO is talking about a learning gulf, because more and more children from minorities, girls, children with disabilities, they have continued to fall between the cracks. The 7th one, your digital footprint must be protected. Often when we talk about the internet, we tend to forget about the fact that children are actually a critical stakeholder in that conversation. There is currently a negotiation that is going on in New York about the digital compact. And there are a number of stakeholders that are trying to make sure that children are not just an afterthought, but actually at the center of these conversations. And 8, you might be the least trusting generation of citizens ever. This is damning too. And it has implications about the implementation of the Convention on the Rights of the Child, but also the role that we play as the UN Committee on the Rights of the Child. Now, this slide is relatively fairly straightforward. These are some of the points that were already addressed by Jamil kindly, and then I'll be very brief here. Now, reporting plays a very critical role. First of all, it's a legal obligation. It offers a critical self-assessment. States look at their obligations under the convention, in this particular case, the UN Convention on the Rights of the Child, and they say, what is it that we've made progress on? What are the challenges that we're facing? I have seen many occasions where states actually came to the UN Committee on the Rights of the Child, and they actually said, it was only in the process of drafting the report to the committee that we realized that why data collection on this specific topic is very low. We realized that why the Ministry of Education is doing a certain thing in a certain way. We realized that some of the challenge that law enforcement officials are actually facing is related to verifying the age of children. So we often tend to take it that, government works with the same purpose, the same priority, the same focus, with the same goal. It's not always the case. And usually, This critical self-assessment allows states to come in a better cohesive manner, to understand each other's mandate, but also appreciate the opportunities and the challenge. It's a comprehensive review. It's about monitoring progress and identifying problems and shortcomings. And I can assure you, I have sat in reviews after reviews, both at the UN level, but also at the African Union level. In the majority of instances, states are interested in putting their best foot forward. They don't come all the way to Geneva to only talk about the challenge that they're facing. In the majority of instances, in their reports, in the conversation, in the dialogue, they want to portray the progress that they have made, and they want to be acknowledged for the progresses that they have made. But the reporting cycle is not just only about progress. It's also about identifying problems, challenges, and how the state plans to move forward in addressing this challenge with a view to ensure the enjoyment of the rights that are contained in the specific instrument, in this case, the CRC. It helps to plan and develop policies. It's an intergovernmental response and coordination. Consultation with civil society organizations, as was alluded to earlier, becomes very important, and it often leads to public scrutiny, and I'll say a word or two about the role of civil societies. It enables governments to know their own national situations. And again, as I said earlier, we cannot make the assumption that all governments, at least the different branches of governments or the different ministries, and from a children's rights point of view, it's not just only education, it's not just only healthcare. The army has implications for children's rights. Data collection has implications for children's rights. Law enforcement officials and the work that they do has implications for children's rights. So it's a whole range of intersectoral stakeholders that would have implications for the manner in which the convention is implemented, and to respond and provide information in relation to how it's being implemented in the state party. The reporting process also helps with raising awareness, enlisting assistance, not just only domestically, but also internationally and regionally. And maybe a final point, national dialogue in a number of instances seems to happen when the reporting process is unfolding. Now, for the Convention on the Rights of the Child, what are state parties reporting on? And I'll just give you a look and feel of some of the issues that they actually bring under the reporting. General measures of implementation is very important. This is where they talk about the legislative measures that they have undertaken, the amendments and new legislations that they've brought forward, and some of the plans that they have in moving forward. In a number of occasions, states would say, our constitution actually recognizes the best interest of the child. We are currently working on a comprehensive child justice bill that will actually provide for the minimum age of criminal responsibility. It will provide for focus group discussions. It will provide for rehabilitation opportunities and referral services. And it will look at children primarily as children and not really as perpetrators. So they provide some details. They also, the conversation about legislation is not just only about vertical, about ratifying and about constitutions and so forth. It's also about horizontal. We often hear how states are undertaking measures, legislative measures, to align their laws among various laws. Maybe there may be customary laws, traditional laws, or religious laws, some of them formally adopted. And that horizontal conversation is also important from the point of view of legislation. They also talk about policies, national plans of actions on children that are intended to implement the provisions of the Convention on the Rights of the Child. This is also the section where they talk about budgeting. As I said earlier, budgets are important. Disaggregated budgets, which also show the budget on education, on healthcare, focusing on children, are important. But when we talk about budgets in our review of state party reports, we're not just only talking about allocations. We're also talking about expenditures. Because from experience, we've seen that there are a number of occasions, and I have a smile on my face because I know a few occasions that are very close to myself as a person, where budgets were allocated, but then a disaster struck, maybe an armed conflict started, or a disaster pertaining to climate took place, or a significant number of refugees came into the country, and then the governments had to divert the budgets to address those issues. And I remember in one occasion, I'm not going to mention which country, but it was an Eastern European country. During the tea time, during the conversation, during tea time, with the microphones off, the head of the delegation said, I hope the committee can actually make the recommendations pertaining to budgeting as solid and as strong as possible. Because he said, usually when disaster strikes, it's my budget that often gets cut. And that's a very interesting observation, because that's a head of a delegation making an admission, not while the microphone is on, but off microphone, to tell us some of the dynamics that actually exist at the national level. General measures is also where we have conversations about the role of civil society organizations. You know, in some countries, we're not talking about the civil society space dwindling. We're actually talking about the civil society space that has disappeared. And civil society organizations play a very critical role. But here, when we talk about civil society organizations, we also warn states not to over-rely on civil society organizations for some core services that they need to take ownership of. And I remember a few years ago, before the migration, when the migration crisis hit Europe, 2016, 2017, quite a number of developing countries had their fundings cut that they were receiving from civil society organizations, development partners. And part of the thinking, and some of it is captured in the literature, was that these countries should have actually moved away from over-reliance on this funding that was coming from civil society organizations. Some of this funding I'm talking about are for core services, for instance, for referral services to children that have been sexually abused, and so forth, so forth. So it's not just only the space, it's not just only the engagement, it's not just only about making sure that there's a conducive environment for collaboration with civil society organizations, but also making sure that you don't over-rely on civil society organizations for core services. This is also where we talk about, data as well. Data, disaggregated data. I remember a conversation, it's available in public, where my own country, Ethiopia, came to the Committee on the Rights of the Child, and there was a conversation about children with disabilities. And in the government's report, it was written that there were 20,000 children with disabilities in the state party at that stage. There were around 100 million people in the country at that stage. That can't be the case. If you look at the data from WHO, we're talking about 10 to 15% that are actually persons with disabilities. And the state party actually realized, they said that, no, we actually need to look at our definition and description to make sure that the data reflects a realistic figure. There are many occasions about children with disabilities, about girls and boys, about attending school, children who actually drop out of school, access to healthcare services, a whole range of, and data collection is also important to prevent significant violations of children's rights, including the application of the death penalty. Now, let me stop there in relation to general measures of implementation, but suffice for me to add that this is also where we engage with states about the role of the business sector, how they're actually collaborating with the business sector, how they're holding the business sector accountable, how they are engaging with national human rights institutions, not just only NGOs, and so forth, so forth. Definition of a child, it's absolutely critical. I'll be very brief here. This is where we engage states about how they define a child. A child is a person below the age of 18, unless majorities attend earlier. That's pretty much the message that Article 1 of the Convention on the Rights of the Child provides. But the definition of a child is also about minimum ages for various activities. For example, minimum age to enter into a contract, minimum age for child labor related issues, minimum age for child work and child labor, the distinction being technical, minimum ages to be sued under one's name, minimum age for completion of compulsory primary education. So various ages are absolutely important. Now, the definition of a child is critical, because when someone asks the question, who does the Convention on the Rights of the Child apply to? That will basically define the scope of application of the very instrument. So it's a provision that has implications for inclusion or exclusion. We know for a fact when age determination issues become very problematic and difficult, the tendency is that children often fall between the cracks. A good example in this case is age determination processes in a number of European countries. Spain comes to mind because we have had a number of cases come before the Committee on the Rights of the Child, where a child arrives as a migrant, asylum seeker, and so forth, doesn't have any documentation, and there is a process to do age determination, but that process is not definitive. It usually has a plus minus 2 years gap. Usually, as a committee, what we say is, when in doubt, when there is no conclusive evidence about the age of a young person, it's better to assume that that young person is below the age of 18 so that he or she can benefit from the protection within the convention. The general principles, non-discrimination is important. The best interest of the child is absolutely critical. the right to life, survival, and development, including not just only in relation to the application of the death penalty, but also in relation to children who die before celebrating their 5th birthday, issues pertaining to infant mortality, road accidents, drownings. 15,000 children die every day as a result of preventable diseases throughout the world in the year 2024. That's an indictment on the international community. And that conversation is absolutely important. And the fourth one is Article 12 on child participation. The drafters of the Convention on the Rights of the Child had the foresight to include taking children's views into account and giving it due consideration as a right, even though the Convention on the Rights of the Child itself did not include children's views. Civil rights and freedoms. I've already talked about nationality and the issue of statelessness. Birth registrations, birth certificates are critical. Privacy, religion, freedom of expression, freedom of association, and so forth. They're not just only rights that are provided within the International Covenant on Civil and Political Rights. And even then, they say everyone. I speak English as a second language. Everyone means everyone, and it should include children too. But often, and I personally use this wording, and I hope my colleagues on the committee can forgive me, I often say Articles 13 to 17 of the Convention on the Rights of the Child are the orphans of various stakeholders, because we often do not pay enough attention to children's freedom of expression, privacy, association, access to information, and so forth. Violence against children is a very critical one. Issues pertaining to sexual abuse, issues pertaining to corporal punishment, issues pertaining to harmful practices, child marriage, female genital mutilation, and a very long and broad range of harmful practices that exist throughout the world. Child witnesses and victims, and how they are actually handled in a child-friendly manner. Family environment and alternative care. This is where we deal with issues pertaining to supporting families to make sure that families are not separated, making sure that when children are separated, that alternative care is provided. When alternative care is provided, the best interest of the child has to be central. The role of foster cares, the minimal role of alternative care institutions, particularly large institutions, over time having very minimal role. Maybe you might know about some of the conversation in Africa, but also in Eastern Europe, particularly for children with disabilities. This is also where we raise questions pertaining to children that are imprisoned with their parents. In many instances with their mothers, but in other instances maybe with their fathers as well. Disability is critical. The Convention on the Rights of the Child under Article 23 provides a solid provision on the rights of children with disabilities. And in fact, that provision doesn't have any reservations. And quite a lot of the work that we do is very much aligned with what the Committee on the Rights of Persons with Disabilities does. In fact, disability is not described or defined in the Convention on the Rights of the Child. We use the definition or description from the Convention on the Rights of Persons with Disabilities. Basic health and welfare. Here we deal with exclusive breastfeeding, malnutrition, stunting, vaccination coverage, issues pertaining to malaria, issues pertaining to obesity, attention deficit disorders, overdiagnosis in some countries, and so forth, so forth. And it's a very important provision where every single country, state party that comes before the Committee on the Rights of the Child, there is always a conversation to be had in relation to basic health and welfare. And increasingly, we're having conversations about mental health and the mental health of children, drug abuse, alcohol abuse, and the manner in which children who are accessing healthcare, issues pertaining to sexual and reproductive health rights is one of the issues that is discussed here. Under Cluster 9, education, fairly straightforward, free and compulsory primary education. I talked about the learning gap and the learning gulf that we're experiencing currently, the role of language, children's right to play. We talk about secondary education, primary education means compulsory and secondary education, affordability, accessibility, availability, and so forth. The 4 A's are often captured here. In a number of instances, we also engage in issues that are not really directly children's rights issues, but issues that have implications for children's right to education. For example, ghost teachers in some jurisdictions where they're in the books, but they don't come to class. Salaries, the capacity of teachers to provide inclusive education for children with disabilities. These are critical issues that are applicable almost to all 196 states parties to the convention. Special protection measures is a very broad one. Here we did with with child prostitution, child pornography. We deal with trafficking. Issues of children involved in armed conflict is covered here. Abductions are covered here. Migration, refugees, asylum seekers. The issue of children that are in conflict with the law. In fact, in the majority of instances, it's not children that are in conflict with the law. It's the law that is in conflict with the children. Now, here is the CRC reporting cycle. It's often very similar to what is being done by other treaty bodies. The state party prepares and submits its reports. The committee presents its list of issues to the state party. That's step 2. The third one is the state party submits written replies to the list of issues. They clarify some of the misunderstandings, some of the additional information. The committee in the list of issues might say, in your state party report, you do not provide the data on child marriage. Can you please provide that? Then when they reply, they provide that information. In some circumstances, I am an academician. Quite a number of my colleagues on the committee are academicians. But even the non-academician colleagues, I like the expression, there are 3 sides to a story. Your story, my story, and the true story. And to get to the true story as much as possible, you need to do a bit of digging, a bit of looking at things critically, a bit of looking back to look forward. It's important to look at the previous state party report of the state, the concluding observations that were issued to the state, and what are some of the issues that are happening now. It's important to look at the report from national human rights institutions. One of the things that we have had as a benefit as the UN Committee on the Rights of the Child is the fact that we engage very actively with UNICEF. And in many of the countries that we deal with, UNICEF has offices, at least has some presence, either to the country offices or the national committees. So that has actually empowered us as a committee to have as much good information as possible, but we also do our own research. And I have to give here credit to the human rights officers at the Office of the High Commissioner for Human Rights, who do a lot of the heavy lifting in terms of triangulating information, trying to prioritize information, and so forth.
Benyam, can you slow down just a bit for the interpreters, please?
Sorry about that.
Thanks.
So here you can see the constructive dialogue between the committee and the state party delegation. Now, let me pause here very briefly and add a couple of points here. What makes a dialogue constructive? Is it because the members of the committee come wearing a very nice tie and so forth? Is it because we started the dialogue on time? Is it because we're very cordial when we address? We say, thank you very much, as this is the first time that I'm taking the floor. I would like to say welcome to the delegation. You actually have brought us some beautiful sun here in Geneva. Is that or what makes the dialogue constructive is you give credit where credit is due, but you also demand more. When the tone that you use should not come across as if you are judgmental. The tone that you use should not come across as if you are a court. Those are also important considerations. When there are sensitive issues, you need to handle those sensitive issues with the sensitivity that they need to be handled with. It doesn't mean that you're going to shy away from it. Sometimes handling sensitive issues is about timing. You want to avoid a situation where there is a breakdown of relationship or a breakdown of trust in the dialogue between the committee on the one side and the state party on the other. I can encourage you to go and look at one such example, which involves Japan. I think it's before the Committee Against Torture, where the head of the delegation just bursts out angry and says, Japan is a human rights respecting country, and Japan doesn't have problems in relation to torture, and so forth, so forth. If you Google delegation of Japan, torture, Committee Against Torture, you can see how those situations can actually be difficult. Just last year, there was an African country that came for dialogue to Geneva, and they asked, it was before the Human Rights Committee, they asked for a couple of people in the room to be removed, otherwise they're not going to proceed with the dialogue. Then this delegation, was given an opportunity to go to the delegates' room to consult and so forth. And the committee said, look, the rules of the committee actually allow individuals to come into the room because it's an open session. We don't dictate to say, you're not in good hands, you're not aligned with the government's ideas, you have to be out, and you're okay in supporting the government's ideas you're in. And that also led to a breakdown because ultimately the state party walked out. They didn't come back. So there are different angles to constructive dialogue, and all treaty bodies are alive to that. That includes the Committee on the Rights of the Child. The next one says the committee issues its concluding observations on the report. This is where we provide states with what our views are in relation to budgeting, in relation to legislation, in relation to their engagement on national human rights institutions, in relation to data collection, violence against children, special protection measures, health, education, birth registration, nationality. We provide some detailed recommendations. One of the things that we have done since 2016 is that we provide a section at the beginning of the concluding observations that says the following 6 issues should be given some sort of urgent attention by the state party for the purpose of implementation. Those are issues that we consider to be very serious, very important, sometimes very systemic issues that we expect the state party to address them as a matter of priority. And then the last part is the follow-up. I'm just going to skip that. Now, recipes for a good process, and I'll be just 1 minute here. Political will is a choiceless choice. As the Committee on the Rights of the Child, we depend significantly on states' political will to ratify, to write a report, to write a comprehensive report, to submit the report on time, to submit the required information, additional information on the report, to also allow civil society organizations and national human rights institutions some space to engage, to come to the dialogue, to have the relevant people take part in the dialogue. I can assure you, there is no glory necessarily in the number of members of delegation that you bring. China, at one occasion, had 44 members of delegation. I remember the UK had this similar number, and then a significant number were connected online from capital to engage. Now, the number is important, but it's not the deal breaker. We have seen also delegations that are not that large, but the right people, the people who actually roll up their sleeves and do the work at the grassroots level are present. Usually a higher level delegation, but also composed of people who are the technocrats, helps with the conversation and the dialogue to be as informed as possible, but it could also help with the follow-up at a later stage. Use multiple sources, adequate preparation, prioritization, they're important. Human and material resources are important, and good coordination is also a very critical recipe for a good constructive dialogue. Now, here, I pinpoint some do's and don'ts for oversight and engagement. Sometimes it's not just only relevant for the Committee on the Rights of the Child. There is the issue about sensitivities, right? Mandate creep, where some states would say, no, this is not your mandate. I remember a conversation where the committee asked a question on corruption. And the head of delegation almost said, there are no corrupt children in my country. Why are you asking a question on corruption? So there are allegations that, we're going beyond our mandate. That's one challenge. It's a state party review. I put a state party in the sense that, in some instances, for example, Slovakia comes to mind. There are a lot of children, Roma children, facing significant challenge. But it's also important that the conversation cannot just simply be focused on those children only. It also is important that you actually broaden and look at the overall population of children in the state. Secondly, it's a state party review in the sense that it's not really about the work that civil society have done and UN agencies have done. It's actually predominantly about how the state is engaging with them, coordinating with them, and what the state has actually done. Killings by law enforcement officials, they often have significant sensitivities. Some countries push back and they say that there was appropriate use of force, children that are being used in protests and so forth. This is something that we're seeing more and more. In relation to religion and culture that are deeply embedded, sometimes states might be defensive. I remember a conversation that we had with Kenya about polygamy. And the head of the delegation said, it's a red line. We're not going to relook at our position on polygamy. And they're almost of the view that, polygamy is a women's rights issue and maybe it should be CEDAW. They almost seem to suggest that it has no implication on the Convention on the Rights of the Child. So those do happen. Voting records and commitments in other settings. For instance, some states, when they are asked about their voting record in the Security Council, because in the Security Council, children in armed conflict is one topic that comes up. They sort of do not like that. they view that as being a separate process, or even in the Human Rights Council, issues considered more relevant in other instruments. You know, if you ask questions about international criminal law, or if you ask questions, for instance, exclusive breastfeeding is a women's rights issue, but it's also a children's rights issue. But there might be states that actually feel that that's an issue that should be left to CEDAW, and the Committee on the Rights of the Child might not necessarily deal with it. Anti-terrorism legislations, issues considered to be purely internal timing. But a critical one that I want to focus on briefly is the armored conflict agenda. Now, briefly, the armored conflict agenda before the Committee on the Rights of the Child has been there since the creation of the Committee on the Rights of the Child. Armored conflict, make no mistake about it, remains to be a very critical and important issue as far as the implementation of the Convention on the Rights of the Child is concerned. Let me mention 5 facts, 5 things. You know, the notion that says children and not soldiers, because the notion that says child soldiers seems to deprive these children of their childhood, even from a terminology point of view, from a policy, from a legislation point of view. So it's important to keep to keep in mind that these are, to begin and to end with, they are actually children. That's an important part. The second one is the 6 grave breaches remain to be critical issues of children's rights. The 6 grave breaches are killing and maiming, recruitment and use, abduction, sexual violence, attacks on education and healthcare, and the issue of denial of humanitarian access. That's the second part. The third one is girls are also affected as a result of armed conflicts. I can mention a data from 2020 in Sudan. Out of the 317 grave violations that were verified in Sudan in 2020, half of them were against girls. So this mentality that says armed conflict is just only almost a boys issue. No, girls need to be looked at in some detail too. And the fourth part is the numbers are very critical. For example, from 2005 to 2020, 93,000 children were verified as being recruited in different parts of the world. 93,000. And that, the United Nations says, is still an understatement. So it's important to look at the numbers, and I'm just focusing on one violation. And finally, there is significant politicization of the children's rights and armed conflict agenda. It's very unfortunate. In fact, at the Security Council, there is a monitoring and reporting mechanism that has been established there for a number of years. It's a naming and shaming process as well. In 2020, Watchlist, which is an organization, actually assembled a group of people, and we were called, I was part of the group, Eminent Persons Group, and we actually reviewed the record of that process, the naming and shaming process at the United Nations Security Council from 2010 to 2020. The first thing that we found out was that the process still is critical and delivers for children's rights, make no mistake about it. But we also found out a number of gaps, because we found out that there are multiple instances where violations have been undertaken, but countries were not listed. Or there were severe examples. For example, 8 parties to a conflict over a review of the 2010-2020 period that were responsible for killing and maiming more than 100 children in 1-year period were not listed. And there was no explanation why they were not being listed. For example, international forces in Afghanistan, in the Democratic Republic of Congo, in Nigeria, Yemen, and so forth. There are a number of examples where states or armored groups, often states, were removed from the naming and shaming list prematurely. This was the case in the context of Tatmadaw in Myanmar. So the politicization of children's rights, particularly in the context of armored conflict, remains to be a very significant challenge. Now, here what you see on the screen are, it says these are just examples focusing on Gaza, but it also says there are examples in Sudan, Yemen, Ukraine, you name it. Now, I'm just sharing a snippet here. These are 3 statements that the UN Committee on the Rights of the Child made in the last few months. The first one on November 2023 one. You can see the quote there. It talks about protection should be provided to all children during the first months. What has been the impact? It talks about maiming, injury, abduction, forced displacement, deprivation of medical care, food and water. It also talks about the need to have ceasefire, but we also mention about the child hostages that have been taken. In the second statement, I'm just sharing a snippet here. You can see here that it's a child rights statement on children in Gaza. Israel was scheduled for a review, but they didn't come. Maybe this is one of the limitations of the treaty body system, but the committee still went ahead and issued a statement. You can see the second bullet. The committee deeply regrets that it has not had the opportunity to review Israel when time is of the essence. The rights of children living under the state of Israel, effective control are being gravely violated, and so forth. It says at a level rarely been seen in recent history. The third one from March, focusing on, it says Gaza halt the war now to save children from dying of imminent famine, UN committee warns. And these are the three statements that have been issued. I've just shared with you some of the elements that are contained in there. It also shows the level of the gravity of the violations that the committee is actually doing. But to a certain extent, it also shows the limitations of the treaty body system to actually react, because we're very much often dependent on states coming for a review before the committee for us to have that constructive dialogue with them. Now, I'll be finishing in less than 5 minutes. Some reflections on impact. This is in relation to corporal punishment. The committee has issued recommendations pertaining to corporal punishment for a long period of time. In fact, yesterday and the day before yesterday, this number of 65 states that have banned corporal punishment in all settings has increased, because we have Lao PDR, the latest state being 66, and then Sri Lanka as being 67. Here you can see the global map. Mauritius was the 65th. I've just mentioned 66 and 67, but you can see the missing huge numbers. Is 67 a good number? It's a good number to work with. It is something that we can actually be grossly happy about? Absolutely not. We want to see corporal punishment banned in all settings throughout the world, but you can see the map that shows that the blue one, which says still lawful in some or all settings. Other areas where we have made impact on education, for the rolling out of free and compulsory primary education. In relation to addressing the rights of children with albinism, in 15 African countries, they are attacked for their body parts. The conversation about climate change has significantly become a child rights issue. In fact, from an individual complaints mechanism process point of view, the famous case that is called the Greta Thunberg case, the Saatchi case, is something that the Committee on the Rights of the Child has decided on migration as well. Now, challenge. I've already mentioned children in armed conflict. Reprisals are still a real challenge. Civil society that are being attacked, and so forth. In some regions, and I'm not going to mention which ones, someone said the other day that the biggest joke in town is you open your mouth only when you go to the dentist. Because if you say something, you could actually get in trouble. And we are seeing that in children's rights engagements as well. Over-politicization is a point that I've mentioned. Cooperation with other treaty bodies remains very critical. The Committee on the Rights of the Child has cooperated with CEDAW on harmful practices. We have engaged with the Committee on the Rights of Persons with Disabilities on alternative care and children. CEDAW and CRPD have tried to engage on a sensitive topic on abortion, because CEDAW views it from a women's rights point of view, almost predominantly. And then CRPD says, you know, in many instances, it's children with disabilities that are aborted. So that's discrimination against persons with disabilities. So you might have a situation where jurisprudence and advice is being given to states that might actually be conflicting, but coming from the same United Nations treaty body system. So cooperation is very important from a number of angles. Here is just a sum. Here's just a picture. Let me briefly say in 2 minutes. At the regional level, there is the African Committee of Experts on the Rights and Welfare of the Child, the African Commission on Human and People's Rights, and the African Court. As someone who spent 11 years on the African Committee of Experts on the Rights and Welfare of the Child, I've seen the added value of engagement at the regional level as well. I have seen instances where there are more substantive provisions in the regional instrument than you can find at the international level. For instance, in this case, the issue of about the girl child. At the time of adoption, children living under apartheid, the provisions on using children in the form of begging, children with albinism, issues pertaining to free and compulsory primary education, issues pertaining to providing support for gifted children. The provisions in relation to children in armed conflict within the African Charter on the Rights and Welfare of the Child are much more solid and concrete than you can find under other international human rights law. For instance, it talks about the fact that the rules will have to apply both in internal armed conflict and international armed conflict. It also talks about the fact that the thresholds pertaining to armed conflict, when they are lower, can be applied in other lower threshold issues as well. Let me stop here. I'll be happy to reflect on points as the conversation evolves. My final point is the following. If I am asked if a child born today in the year 2024 is better off than a child born in 1989 or 1990, the answer is yes, but not every child. Children with disabilities, children of minorities, children that are stateless, in some instances, girls, children living in poverty, children in armed conflict continue to fall between the cracks. And that's a challenge that the Committee on the Rights of the Child tries to tackle by providing guidance to states. Over to you, Marjorie. Thank you very much.
Thank you so much, Benyam, for your clear explanation of the treaty framework for protecting children's rights, the violation of children's rights, particularly in Gaza, challenges facing the committee, and a brief look at the African regional system. Thank you so much. And our final presenter is Olivier. Olivier, over to you.
Thank you very much indeed, Marjorie, and very warm welcome to all the participants in this discussion. I should start by saying how interesting I think the presentations by Benyam focusing on the Committee on the Rights of the Child and the treaty bodies in general, and the introductory presentation by Jamil Dakwar were. I think they provide an excellent overview of the issues that they covered. And what I will do is quite, I hope, complementary. Like Jamil and Benyam, I will try to provide you with some insights as to how the special procedures of the Human Rights Council function, based on the experience I gained as Special Rapporteur on the right to food between 2008 2014, and currently as the Special Rapporteur on extreme poverty and human rights. There is indeed a gap between what we can read on paper concerning how these different UN mechanisms function and what is the practice of these bodies and of the experts that operate within them. And that is, I think, why the contributions of Benyam and Jamil were so valuable. Let me perhaps use this PowerPoint presentation to present the topic I will address. The establishment of the Human Rights Council in 2006-2007 was already presented by Jamil Dakwar a few minutes ago, and he rightly noted the improvements made to the system when the Human Rights Council succeeded the Commission on Human Rights, which for 60 years, between 1945 and 2005, when it held its last session, was the forum within the United Nations system where human rights were discussed between the governments. The Commission on Human Rights grew in size as membership of the UN expanded with the decolonization processes of the 1960s and 50s and 60s. So that at the end of the 60 years during which it was functioning, the Commission on Human Rights had 53 member states. And one of the reasons why the Human Rights Council was established was to establish a body that would be more credible, thanks to a more narrow membership based on the states sitting on the Human Rights Council having to be selected for their human rights record. And one of the ideas that was floated when the Human Rights Council was proposed was that the Human Rights Council should be composed only of countries that have, if you wish, a strong human rights record, could not be accused of human rights violations, and thus could be credible in upholding human rights within the UN system. And that is one of the scenarios that was explored after Kofi Annan, then the Secretary General of the UN, presented his report In Larger Freedom, where the proposal was made to establish a Human Rights Council. But that scenario was not really followed, as Jamil rightly emphasized, whereas the states seeking to be elected to the Human Rights Council by the General Assembly do pledge to cooperate with the system. In particular, they pledge to cooperate with these special procedures, which I'm going to describe. They are not actually chosen based on their past achievements. And we still have a situation in which the Human Rights Council includes some states that do not have a clean human rights record, far from that. But the reality is no state is absolutely stainless. All states have their problems. They may be different for rich countries and poor countries, for countries that have a lack of an independent judiciary, or countries that have widespread land grabbing taking place under their jurisdiction. So the problems are different, but all countries have issues that meant that a proposal according to which only the clean states could be elected to the Human Rights Council would not have been viable anyway. However, the Human Rights Council has a more narrow membership in terms of numbers. It's 47 member states. And when it succeeded the Human Rights Commission, one of the, I'm just going to pass on this because it was discussed quite eloquently by Jamil. When the Human Rights Council succeeded the Human Rights Commission, it borrowed from the Commission on Human Rights a number of tools, adding to the tools that already were in existence the Universal Periodic Review that Jamil described, that the Commission on Human Rights was not able to rely on. So that was the main innovation when the Human Rights Council was established. It was to add this additional mechanism to which all member states are subjected, and which introduces a stronger form of peer review with respect to human rights compliance in the human rights system. Now, one of the mechanisms that the Human Rights Council inherited from the Commission on Human Rights was the special procedures. And the special procedures were, in fact, established in the early 1970s as a tool the diplomats of the Commission on Human Rights sought to establish in order to strengthen the ability to address certain violations that they wanted to document more reliably by basing themselves on experts they could trust to do field visits, speak to victims, and report back to the diplomats about what they've seen and what they've heard. The initial establishment of these special procedures took place when Augusto Pinochet removed by a coup d'etat Salvador Allende from Chile's presidency, and when large-scale human rights violations took place in Chile in 1973. And it was then, the system then gradually grew, covering, for example, apartheid in South Africa and in what was then called Southwest Africa, Namibia, and then the system started to grow initially in order to monitor those most delinquent states. Gradually, not only countries were subjected to this monitoring by independent experts, but these independent experts were also appointed in order to report on certain thematic issues. And we have today about 40 mechanisms that fall under the heading special procedures, most of which are special rapporteurs, individual experts tasked to monitor certain areas and to report to the Human Rights Council about what they found through their inquiries and consultations, expert meetings, and field trips. But in addition to special rapporteurs, you have working groups composed of 5 experts, each from one region. As you know, the UN still functions according to these 5 regions, Asia, Africa, Latin America and the Caribbean, Eastern Europe, and finally, the rather awkward Western Europe and other group, WEOG, that brings together Western European countries and Canada, the US, New Zealand, and Australia. So these working groups of 5 experts have 1 expert per region in order to ensure geographical representativity. And in general, across the system, the regions, well, there's a balance sought between the different regions with respect to where the experts come from. So you have special rapporteurs, you have these working groups of independent experts. Some mandates still are described as mandates of independent experts, but really we are all independent experts. It's just that some are called independent experts instead of special rapporteurs. And then you have one specific category, which are the special representatives of the Secretary General. For example, in the years 2005, 2011, the Human Rights Council, well, initially the Commission on Human Rights and then the Human Rights Council, received reports from Professor John Ruggie as the special representative of the Secretary General on the issue of transnational corporations and other business enterprises and human rights. So John Ruggie was appointed by the UN Secretary General, but at the request of the Commission on Human Rights and later the Human Rights Council. That is the only difference. Otherwise, the special representatives of the Secretary General, although they owe their appointment to the Secretary General, they report in the same way and provide the same kind of information to the governments sitting in the Human Rights Council. And here on this slide, you have some examples of the mandates that have been established as special procedures of the Human Rights Council. It's not a full list. The full list would be perhaps too long to go through, but this is a snapshot and a sort of sample of the kind of mandates that have been provided that cover either certain thematic areas, rights or issues, sometimes specific groups that, for example, are covered by the working group on people of African descent. And then some of the mandates are country specific. When a country is considered to potentially have committed widespread and flagrant violations of human rights, one of the options of the Human Rights Council when receiving a complaint in this regard is to appoint a country-specific independent expert that will then report on the situation of human rights in that country. And of course, that is often resisted by the country in question, which may, and actually not unusually does, choose not to cooperate with that independent expert, but nevertheless, the mandates allows the Human Rights Council to be informed in real time about developments related to human rights in that country. Let me discuss in greater detail how these special procedures operate. And it's important because it's a rather unique system, poorly understood, on which very little academic studies have been able to focus, and where practice matters much more than the texts establishing these mandates. First of all, let me say a few words about how these independent experts, special rapporteurs, independent experts, experts sitting on these working groups or special representatives of the UN Secretary General are appointed. I leave aside again this last category of special representatives of the UN Secretary General because of the fact that they are appointed, as I said, by the Secretary General. But how are the other independent experts chosen? Well, before 2007, before the entering into function of the Human Rights Council, the appointments were very much the result of diplomatic negotiations, bargaining between states, and the procedure was neither transparent nor always entirely objective. Although there was an expectation that the experts would have the minimum qualifications required to be credible in their role, the main reason why they were appointed was simply that the state of which they were the national, or indeed other governments, were able to support them well enough through a diplomatic negotiation. Now, this has been changing in recent years. Today, there is a procedure that is described by Resolution 5/1 of the Human Rights Council that is much more objective. Essentially, when a position is to be filled, there is a call for applications. The applications can be made by individuals nominating themselves. They can be made by governments, by NGOs. And there is a selection procedure that operates through two stages. A first stage based on the assessment of the CVs, the resumes of the experts, results in a short list being established, and then the shortlisted candidates are interviewed by a group of 5 diplomats that try to understand better the vision of the expert for the mandate, why he or she is interested in taking the position, what his or her strong points may be, and what he or she will contribute to the mandate. And then the group proposes a name to the president of the Human Rights Council, who mostly follows the advice given by the group and the ranking of the candidates by that group of diplomats. Sometimes the president may deviate from what is proposed, typically in order to strengthen or ensure adequate representation of women or of certain underrepresented regions. As I said, across the system, there's a entirely understandable desire to achieve a balance between women and men and between different regions, so that the selection based only on the individual qualifications of individual applicants to positions within the system would not be sufficient. That, per definition, cannot be fully taken into account by the group of diplomats making proposals to the president of the Human Rights Council. However, mostly the ranking proposed by the group, the working group of diplomats, it will be followed. and that is what the president will then propose to the Human Rights Council, and that is then ratified without much debate. These mandates are for 3 years, renewable once, and that the renewal of the mandate after the initial period of 3 years is more or less automatic. If the rapporteur or the independent expert wishes to continue, he or she will generally be renewed in his or her mandate unless something very exceptional has occurred, or unless there is very strong competition from particularly a person from his or her region or nationality, at least in the working groups, that is what may happen. So that is, in a nutshell, how these independent experts are appointed. It's important to note that many of them are academics. The reason being not only that it is within academia that usually the strongest expertise can be found, at least the academic expertise per definition, but also because the mandate is extremely demanding on time. I consider that I dedicate 80% of my time to the mandate, 4 days per week. And of course, that is only possible when, as an academic, you can choose when to teach, and when, as an academic, you have months during which you are not obliged to teach because you're not in the academic period, and during which you therefore can do country missions. It is very difficult for people who are not academics to occupy such a position, except, of course, when you are a retired diplomat, for example. But that explains the overrepresentation of academics, which sometimes can be a problem because, of course, the knowledge of practitioners, the expertise gained from being on the front line of human rights as an activist may be actually at least as precious as when you have an expertise as an academic. Let me now turn to what I think is the most important, which is the tools that the special rapporteurs on whom I will focus have at their disposal and how they use these tools. Essentially, special rapporteurs or independent experts that have to report on certain thematic issues have 3 tools at their disposal. They have the possibility to conduct country visits. They can write communications, allegation letters to governments. And thirdly, they present usually 2 thematic reports per year, respectively to the Human Rights Council in Geneva and before the 3rd Committee of the General Assembly in New York. Let me address the 3 tools in turn, and then I will discuss in looser terms the relationships between these independent experts and the diplomats of the Human Rights Council that sometimes have been quite tense and difficult, although they also can be very, very cordial. So let me start with country visits. As I said, starting in the 1970s, the main reason for appointing special procedures was for diplomats to be informed about what was happening on the ground, have reliable information on which to base themselves. This is a photograph which is that of my very first mission as special rapporteur on the right to food. I was in Benin in 2008, shortly after having been appointed in my new role. And I speak here with a farmer who shows me one seed that he is using. And the country visits are especially useful because essentially this is a unique opportunity for the UN human rights system to have a contact with local actors, civil society groups, unions, social movements, destitute people who would never dream of traveling to Geneva or New York, and to speak to local public officials who very often have no contact with the UN except humanitarian agencies in the most desperate situations. So it is this contact with the field, with the real people who are struggling for their rights. That is the main added value of these special rapporteurs being able to travel. We normally are able to do 2 country visits per year, although due to the liquidity crisis within the UN in recent months, this has now been limited to 1 per year for now, at least for 2024. It probably will be only 1 that we will be able to do. And these visits last typically for 10 days, 2 weeks, allowing us to travel across the country. But of course, particularly for larger countries, we are not quite able to cover the full range of issues that would be relevant to our mandate. These country visits are organized in close collaboration with the government that receives us. Although the government organizes only the official meetings with officials of the government, including local government, and we dedicate about half of the time to exchanges, conversations, consultations with NGOs, unions, human rights defenders outside the purview of the government. And indeed, those meetings are held in strict confidentiality to protect our sources. And although they're extremely useful and informative, they would not appear on the official agenda. The government is informed about where we go because they need to, alert us if there are security issues in certain locations, for example. But they are not informed about whom we meet. And of course, the content of the discussions is not revealed to official authorities. So about half of the time is spent speaking to officials, half of the time is spent to non-governmental organizations, unions, activists, and so on. And we usually can dedicate 4 or 5 days to 1, mostly 2 field visits far away from the capital or the capital region. It depends, of course, on the breadth of the country, whether or not we are able to cover a variety of issues. These missions are made possible on the condition, of course, that the government invites us. And that is a major obstacle. When I started in the system in 2008 as Special Rapporteur on the right to food, it was easier than it has become now to obtain an invitation to visit the country. Today, I have to write maybe 10 letters to governments to get 1 invitation. And even then, the invitation is not always easy to honor because the invitation is provided in, say, December 2023, after I wrote a letter in June 2023, and the invitation says that perhaps the visit should take place in 2025. So it makes it very difficult to plan visits well, as we depend entirely on the willingness of the government to accommodate the visit. And it is true that the visit of a special rapporteur requires the government to organize meetings, to ensure some ministers are available, to ensure that the visit does not interfere too much with, for example, an electoral process or other potential sources of instability in the country and so on. Anyway, there are many reasons why governments may not want to be visited by special rapporteurs, although they are meant to cooperate with the system, although many of them, when elected to the Human Rights Council, have pledged to cooperate with the system. Many of them try to use various pretexts not to invite us. Now, a number of governments have accepted the principle of a standing invitation, and by the last count, some 128 states had agreed to provide such standing invitations, which in theory means that we should be able to write to them and, referring to the fact that they have a standing invitation, explain that we intend to travel to that country in June 2024. That is not, however, quite how it works. When you have such a standing invitation, you still have to negotiate with the country about the date, and as I said, there are many reasons why governments may want to postpone a particular visit. So in the end, it depends on the goodwill of the government whether or not you'll be able to visit. And I have been in touch with some countries who have standing invitations for years, and I was unable to obtain from them an invitation. This, however, gives you an idea of the standing invitations that exist per regional group. The Western Europe and other group, WEOG, and the Eastern European group have a high rate of countries having extended these standing invitations. But again, that is not by any means a guarantee that those standing invitations will be honored. This is the regional distribution of these standing invitations. As you can see, in theory, this apple pie would cover the countries that have agreed to a standing invitation. We should be able to pick and choose which country to visit, but as I explained, this is not quite how it happens. This is a map that shows in blue the countries that have a standing invitation to special rapporteurs, and this just confirms the information you just have seen. Now, what in practice happens during these country visits, and what is their usefulness? Well, this is a picture of my latest country visit, which was to Ecuador in August 2023. And you see I'm here sitting with Afro-Ecuadorians, a group that is suffering from various types of discrimination in the country. I'm there with one personal advisor and one staff of the Office of the High Commissioner for Human Rights, plus interpreters. And the purpose of that kind of exchange is to collect information from the ground and then to report back to the government about what I've seen and heard. Ask to the government to explain its position, what it intends to do to remedy the situation I could document. And that leads to an exchange with the government and allows me to draw then my own conclusions. These conclusions are presented first at the end of the mission in what we call an end of mission statement, which is a relatively short document. I mean, sometimes they are longer, but usually they don't exceed 8 to 10 pages. And those end of mission statements are an initial set of conclusions drawn from what we could document by our field trips, our exchanges with the activists and so on. And this end of mission statement is a very important document because it is presented to the local media at the press conference that closes the mission. This has an impact that is far more important than any discussion that can take place in Geneva or New York, in the interactive dialogue special rapporteurs have with the Human Rights Council, or in the constructive dialogues that treaty bodies have with governments, because we speak directly to the local media, we can put pressure on the government to make certain commitments, to respond to certain questions. And the local media can be extremely effective in giving the publicity to these recommendations in the pages of the newspapers there. And sometimes it is a tough relationship with the government, because they fear more than what happens in Geneva and New York. They fear the reputation, they fear for the reputation when someone with a UN hat, basically, in the capital city, speaks to the local media and expresses certain sources of concern. I was, for example, in Beijing, in China, in December 2010, as special rapporteur on the right to food. It was a very interesting mission. China, at the time, was keen to strengthen its reputation within the UN human rights system. And they agreed to my visit as special rapporteur on the right to food, probably based on their understanding that the right to food was about producing enough to feed the country. But of course, the right to food is about many other things, including the right not to be evicted from one's land as a small farmer, the protection against corruption, the quality of food, the nutritious quality of food, rather than just the quantity of calories available, and so on. And I have to say that the Chinese government was rather surprised by the challenges I presented the government with. And really, that is how I would like to describe our role. It is to present the government with a mirror of the country, forcing the government to see certain things that it would be more convenient to ignore. So obviously, we cannot become experts in 2 weeks' time of a particular country. Although these missions are prepared many months in advance, and although we could do many readings and have consultations prior even to entering the country, we are not experts of the country. They are the experts, the government, the local population, of course. But we can stimulate a dialogue between civil society groups and the government. We can present the government with certain challenges it is tempting to ignore. We can alert the local media to certain issues they will then follow upon and perhaps ask questions about. And yes, our findings can serve then NGOs to continue their struggle and to put pressure on the government. This is the final press conference I held in Beijing at the end of my mission there. I have to say that sometimes these country missions can be extremely significant. I was in Syria in September 2010 as special rapporteur on the right to food, and that was after 4 or 5 years of droughts in the northeastern part of Syria that is dominated by the Kurdish minority. And because of the drought and the lack of response from the central government of Damas, many people had migrated from that region, the capital city of which is Halake, and they'd migrated to Aleppo, to Damas, to Homs, crowding the outskirts of these cities. For those who could pay, they rented apartments. They put a burden, of course, on public services in a context in which Syria had already been receiving quite a few refugees from Iraq following the conflict that started in 2003. And I told the government of Syria that they had a crisis on their hands, that the population was growing impatient, that the prices of housing and food were exploding, and that public services in these cities were overwhelmed. And the response I got was, do not worry, things are under control. And this was, of course, 6 months before the riots started in Homs that started more than 10 years of civil war in the country. So I think our role as the eyes and ears of the international community, as I said, and as whistleblowers, basically, alerting the government to certain things it may prefer to ignore, can be in some cases important. Now, the second tool we have, I will speed up a bit, are the urgent appeals or allegation letters. Basically, what this means is that we can receive information from NGOs, human rights activists, victims of violations. And if we believe that information is solid, credible, if we believe the communication we receive is well documented, we then write to the government. We send a letter. This is generically called a communication to the government. The term is a bit misleading because although we write a communication to the government, it's on the basis of another communication we've received from NGOs or victims of violations. And those communications to the government either take the form of urgent appeals when violations are unfolding and we want to prevent them from continuing, and the government is expected to respond within 30 days, or they take the form of allegation letters, normal allegation letters, in which case the government has 6 weeks to respond. We can decide to make public the fact that we've written to the government in cases where this is justified by the emergency and the need to put pressure on the government. We must, however, leave the government at least 48 hours to react before we communicate publicly. But apart from that, we can, if we feel that it is justified, send out a press release announcing that we've urgently appealed on the government to do certain things or to abstain from doing certain things. For example, eviction of people from a slum that might affect the right to housing. So governments receive this letter. They don't always respond. This is one chart that shows for 2017 how many communications were sent under these different formats, right? Urgent appeals, joint urgent appeals by a number of special procedures joining forces and writing together. Allegation letters or joint allegation letters. These are the 4 columns in different colors you see. And the second batch of columns, if you see what I mean, are the government replies to either the communications sent in 2017, or then the third batch is the replies from governments received in 2017, and then the follow-up they may have given or not to the communications sent. The level of response quite expectedly varies from region to region, mostly because of limited capacity. Some governments are not responding and not providing any follow-up to the communications addressed to them. And what I would like to simply note is that although some countries do respond more or less systematically, this doesn't mean that they take seriously the allegations or act upon them. Some governments, for example, systematically say that we've been misled by the information, by some NGOs, that there's nothing under the sun, and nothing to worry about. And so they dismiss the allegation letter, although they do respond, and they would score well on these indicators that simply look into whether or not the government has responded. What is most significant is the level of follow-up that they give, and that unfortunately remains quite minimal. I should, however, say that the lack of explicit follow-up to the allegation letters does not mean that they've been ineffective. They can serve to protect people. they can serve to notify to the government that a situation is being watched. They can avoid certain violations from repeating themselves after the government has been warned that the international community is looking at the practice or monitoring the situation. So effectiveness of our interventions is sometimes difficult to assess. This doesn't add much to what I've already said, and so I'll just move on. The third tool we have are the thematic reports that we present to the Human Rights Council and to the Third Committee of the General Assembly. What those thematic reports try to do is to provide guidance to governments as to how they should address certain emerging issues based on their human rights obligations. So we try to address new topics for which human rights instruments provide little or no guidance, and we base our reports on expert consultations, academic studies, questionnaires we send out to states in order to compare their practices and so on. And we try to build reports that provide an overview of the issue and the way states have responded and what a human rights response could be. For example, I dedicated a special rapporteur on extreme poverty and human rights most recent reports to the question of whether people are protected from discrimination on grounds of poverty, which is in theory something human rights instruments require, but in practice, very few countries effectively protect people from discrimination based on socioeconomic disadvantage, social status. I did a report on the non-take-up of rights, the fact that people, although having rights on paper, do not effectively enjoy those rights because of a number of concrete obstacles they face when they are in destitute situations. Or I dedicated a report to the issue of the job guarantee as a tool that states can use to provide public works to people on which they can be employed in order to support income security, and so on. So the idea is to open up the political imagination of states, to provide them with new tools they can use to make progress in the fulfillment of their human rights obligations, and to develop comparative studies so that governments can seek inspiration from others. And what works best, in my experience, is to show that your neighbor or that certain states that look like your state are doing better than you, and cross-country comparisons within specific regions are a very effective tool. So, for example, if I address myself to Honduras, mentioning that Salvador is doing well on this particular issue, better than Honduras, that will nudge Honduras into action. Similarly, if I compare Switzerland with France, for example. So that is what these reports try to do, and they lead to a discussion within the General Assembly of the UN, within the Human Rights Council, putting new issues on the radar. Sometimes we manage to get the media to be interested in new topics, particularly when the topic is well chosen and relates to what is of concern to the general public. It is more difficult to put an entirely new issue on the map, although when we succeed in doing that, it is even more valuable. And for example, I can say with great humility that the report I did on non-take-up of rights was effective in drawing the attention of social security administrations to the fact that it's not enough to legislate on the field of social protection. You also needed to understand the very concrete obstacles people face when having, for example, to apply online for a particular benefit, or when having to face social services that were with which you had traumatizing experiences that lead you to not want to have contact with them, and so on. So sometimes it's possible to put new issues on the international agenda. Let me close by saying that the relationships between the governments and the independent experts have sometimes been difficult. There is a code of conduct that guides us. I'm almost finished, Marjorie. I'm just going to very quickly say that this code of conduct defines how we have to operate. I never felt that it was too restrictive on us, but it is used sometimes as a sort of threat by governments, mentioning the code of conduct when they are unhappy about the way one special rapporteur has behaved. And for example, when Philip Alston visited Kenya in February 2009 as special rapporteur on extrajudicial killings, he recommended that the chief of the police, the Attorney General, be removed from his position in order to preserve the integrity of the position. And that was considered by Kenya to be outside the remit of the code of conduct, not something that the special rapporteur should be allowed to do. It led to a tough exchange between Kenya and Philip Alston. And in the end, the president of the Human Rights Council had to intervene. I could say more. I have no time to say more. I look forward to our discussion. Thank you so much.
Thank you so much, Olivier, for explaining the structure of the special procedures, the role of the independent experts, and the limitations and challenges they face. We're running short on time, so I'm just going to briefly outline a few of the questions, and in the time we have left, if any of the faculty want to respond, that would be great. How could the U.S. be elected to the Human Rights Council when it hasn't signed and ratified all of the core human rights treaties? And did the Western countries set up the monitoring system to protect themselves, many of whom are complicit in the genocide in Gaza? How does international law apply when it's private corporations that are violating international law? And has the Race Convention been applied to reparations and affirmative action? So anybody who wants to comment on any of those issues would be great.
Happy to go first, if that's okay. I think it's a fair criticism of the imperfect and sometimes even flawed system of a human rights mechanism, particularly the Human Rights Council membership, that doesn't adequately push and take into account the lack of seriousness, not only in terms of ratification, because the problem with ratification is that you have some countries that ratify treaties but really have not done anything meaningful to implement the treaties. So I would say what we need to look at is the real assessment of the human rights record at the national level, and vis-a-vis also sometimes extraterritorially, what the government is doing outside its territories, because that's also sometimes very problematic. So for the United States, I think it's important to continue to hold the country accountable for existing obligations, calling for more ratification, but more importantly, breaking that exceptionalism with regard to the lack of implementation at the national level. And that's where really there's not been any movement since the ratification of the first human rights treaties in the early 1990s. So that is where I think both national level advocacy, civil society, pressure on the government and policymakers and members of Congress. Obviously, it's up to both the judicial, not only judicial branches of government, but also other political branches of government to be able to do that seriously. On the other question, I think related to reparations, yes, the CERD have taken up the question of the reparations in the last review during the United States government review in August 2022. It was the first time that it has taken it up in a very serious manner, has been raised and asked the US government on the intention to create a commission to study reparations for slavery in the United States. And that was helpful to put it on the record and to continue to raise the issue of reparations, something that the movement for reparations in the United States have done for years and decades, but it got more traction more recently and had been lifted up by civil society organizations at the last CERD review. And there's much more that the CERD and other bodies can do. I know that the Office of the High Commissioner for Human Rights, and particularly the High Commissioner in the Plan of Action for Racial Justice, called for reparations. I know that the Permanent Forum on People of African Descent has also prioritized the issue of reparations. So this is an issue that has been getting wider support from different parts of the UN human rights system. Thank you.
Should I come in briefly?
Yes, go ahead. Mhm.
Yeah, thank you very much. So I agree with Jamil on the US conversation. Maybe one point that came out interestingly from the conversation in the review of the State Party report of the US before CERD is also the conversation around the obligation of the failure of the government to actually to protect historically Black communities from a number of harms of toxic industry. I remember the conversation about Louisiana's Cancer Alley. So I think that link about racism, environmental racism, and the climate justice conversation is also interestingly featuring in the context of the review of CERD. One additional point in relation to US exceptionalism, the US is the only country that has not ratified the UN Convention on the Rights of the Child. We call them the only guilty exception. When I was chair of the committee in 2015, I tried to set up an appointment with the US ambassador in Geneva, Ambassador Harper. And he was kind enough, decent enough. He gave me a platform, had a conversation. His point was that the political environment at the domestic level is so toxic. Just a couple of years before that conversation, CRPD was brought before Congress, and there was no appetite to ratify the CRPD, despite the fact that we know that the Americans with Disabilities Act actually served as a significant basis for a number of concepts in the Convention on the Rights of Persons with Disabilities. So the Convention on the Rights of the Child, that American exceptionalism, some of the arguments that I've heard are about corporal punishment, the family rights, protection of the family, the distinction between what are state jurisdictions and federal government jurisdictions. The right to freedom of religion is one that I have heard come up quite a lot. The right to the highest attainable standard of health is one topic that they have had reservations, I believe, on. A final point, you probably know about the children's rights, the UN, the children's rights and business principles that are actually applicable to children. And in fact, a couple of years ago, there was a 10-year review of those principles. And some of the things that we noticed are, first of all, still the conversation about children's rights in business is focused on child labor. That's a very limited view. There are much more bigger conversations about the impact of the food industry on obesity, on healthcare issues, on climate change. So it is still focused on child labor. And secondly, quite a lot of the obligations that companies are undertaking are optional, that they're not binding. So that continues to undermine the progress that we want to make. And as the Committee on the Rights of the Child, we closely give recommendations to states on children's rights in the business sector. And we have adopted a general comment on the topic, but there are significant gaps as far as implementation is concerned. Over to you, Marjorie.
Yes, thank you. Olivia, couple of minutes to close up.
No, one question I felt was super interesting was the state-centric nature of the UN human rights system that Jamil, Benyam, and I have described until now. I think it's true that violations increasingly can be attributed not just to governments, but also to non-state actors, whether they are international financial institutions, large corporations that are unaccountable to anyone but the shareholders. And that may be seen as a gap in the system. However, special procedures have, to a certain extent, the ability to fill that gap. I have been routinely addressing communications to corporations, most recently to DoorDash, Amazon, and Walmart, on the issue of the wages that they pay and the repression of union rights by these major US corporations. There is the Working Group on Business and Human Rights that monitors transnational corporations and other business enterprises based on the UN Guiding Principles on Business and Human Rights. And my predecessor, Philip Alston, as Special Rapporteur on Extreme Poverty and Human Rights, dedicated full reports to the World Bank and the IMF. So with some inventiveness and audacity, we can move beyond states as the main addressees of human rights obligations.
Well, thank you so much, Jamil, Benyam, and Olivier, for your excellent and comprehensive presentations. Our next program, course 4A, will cover the criminalization of rights and human rights defenders as a means of repression. It will be held on Thursday, May 23rd. We hope you'll all join us. Thank you so much.
Thank you very much.
Thank you, Marjorie. Thank you. It's been such a luxury to be able to enter into the details. Thanks to you. Goodbye.
Thank you very much.
you.
everyone.